Hi guys, it's Kathy. I hope you're doing well. Boy, do I got a different one for you today. It's a revocation hearing, custody. It's custody revocation hearing, but it's way different than anything we've ever seen before. And it's the system working, the best possible outcome for years to come. It's just, we get to see behind the scenes of what happens. Like, we see a lot of, tiny little babies and toddlers that go through the revocation, and the parents are fighting to get their children back, barely. That's not like this one. He's 17 right now, so chances of him getting placed anywhere at this point, he's not placed anywhere. He's in the system, but it's really good. Here we go.
Court dissolves the dependency. What is the status quo there?
Sorry, the judge forgot to turn his mic on for just a few minutes, and we can hear everybody else, and then he remembers to turn his mic on. So just wait a moment.
Legal custody of the children.
It's my understanding Mr. Leopold may want to address, since it's his client with the legal custody.
Yes, Judge. My understanding is Mr. Richards will have legal custody.
Is there already a pre-existing custody order independent of the juvenile court act?
Sorry, I'm not a doctor, but there's one more thing. I'm not a doctor, but I'm going to go out on a limb and say the child is special needs. He's special needs.
No, I don't think there's a separate order, because if I recall correctly, I think he was legitimated as to one, and then the other was born of the marriage. So from the combination of those, he's the legal custodian.
Did they go through a divorce?
No. No, they had the first child was born before they were married, then they got married and also legitimated on the first one.
And they remain married?
Sorry, I didn't quite hear.
They remain married at this time?
Yes, Judge.
Sorry, my microphone was off. I hope you can hear me better now. All right, I'm going to sign this consent order dissolving dependency, which should resolve that action. Ms. Wheeler, are there any remaining issues that the court needs to deal with?
No, Your Honor.
All right.
I do believe that Ms. Salmon did chime in last night late that she was in agreement. And I think there was an issue with your email. We all chimed in yesterday when the draft order was sent to you, but for some reason, I don't know if your email was typed in incorrectly, but the court's emails were bouncing back on all of us. So Ms. Salmon has chimed in twice that she consented to the draft order.
Yep. And I got her emails also. I don't think the court got them, but I agree with that.
All right. I have signed this order. That will resolve that matter. I appreciate your work together on getting this to this point. And y'all are free to go.
Thank you.
Thank you, Your Honor.
Order. All right. Should I go ahead and let well, here comes Ms. Render Connect. Sorry. Ms. Render Connect, good morning. I just relieved the other parties, Mr. Leipold and Ms. Wheeler logged on. I announced that I've reviewed the consent order, and I'm executing that. So y'all are free to go, and that will resolve this matter. I appreciate your work on this to get this to this point.
Thank you, Your Honor.
All right. All right. Let's turn to Hunter Fields. Should I let these folks in? Are we ready for that?
I believe so, Your Honor.
All right.
You can't really see him, but that's the boy on the television in the courtroom. You can barely see him, but he's there.
All right, I'm going to call the matter of Hunter Fields. We're here for an adoption efforts review. I note Ms. Gravitt is here on behalf of the department. Ms. Devine is present in the courtroom as child attorney. And I notice that Hunter is with us by Zoom feed. Good morning to you, Hunter. And I also note that Mr. Amadou is present, serving as guardian ad litem, and he is present in the courtroom. All right.
So he has an attorney and a guardian ad litem.
Ms. Gravitt, do you want to start us off?
Thank you.
Yes, Judge, thank you. I also note that Ms. Shanna Andrews is here on behalf of the department as well.
All right.
Your Honor, I would move to tender the permanency report submitted by the department. I don't believe the filed copy has been returned back yet, but I have the unfiled copy to tender.
All right. Any objection to introduction into evidence of what I'll consider departments 1?
Judge, the only issue on the permanency report is the recommendation. There's a list of things and nothing's checked, so I just would like on the record for the department to verbally recommend whatever their recommendation is.
Okay. Ms. Gravitt, what do you say to that?
Yes, Your Honor, I'm happy to do that. I acknowledge that back page is blank, so I'm happy to clarify that.
Is that something you can do by hand on the document as you introduce it, or is that?
I could do it by hand or orally, whichever is preferred.
Why don't you do it on the both, honestly, so that we have, if it's going to be introduced into evidence, I'd like it to reflect what we're actually doing.
Yes, Your Honor, one moment.
Sure.
And Your Honor, I'm just double checking with my client to make sure I get this information correct.
Sure.
In the interim, I would request a proffer if there would be no objections.
Any objection to proceeding by proffer?
No
All right.
objection, Judge.
Go ahead, Ms. Gravitt.
Thank you, Your Honor. In presuming this permanency report, once we mark it in, gets admitted into evidence, I won't belabor too much of what is already in it. The department is recommending a non-reunification and application plan for the child. Hunter turns 18 June of this year. I believe specifically it's June 23rd. Yes, June 23rd of this year.
That's my birthday.
Is it really?
wow.
Yes.
Ah, nice.
Hunter and I have the same birthday, I guess. Okay.
About that.
Good deal.
I'm gonna turn a little bit more than 18 on this June, but
Just a few years.
But he does turn that 18 on that date, Your Honor, and that's the primary reason for the department's change in the recommended permanency plan. It was previously adoption, non-reunification adoption, but just looking toward Hunter turning 18 and him gaining independence. The department updated the permanency plan to kind of reflect where he's at. At this point in time, he is still placed at Morningstar in Brunswick, Georgia. And I'll add this in as well. It's the department's belief that he will sign back into care and receive, if the court finds it's in his best interest for him to receive extended care youth services upon him turning 18. And it's the department's understanding that he can remain in his current placement at Morningstar until he turns 21.
So that right there is unbelievable. No one adopted him. There's no way that mom's getting custody back ever again. And he's 17. So, within a year he's going to be an adult. And what they're saying is he's an adult, so he can live his own life. But he has the option. He has the option of signing back in for extended juvenile care, which means he's not just going to be thrown out when he turns 18 to fight for his life alone?
The department has observed him there. He does well. I think there are some occasional behavioral concerns, but nothing ultra concerning to the department. Overall, he does really well at that placement. He attends school at Morningstar Academy. He has an IEP in place. As far as services, he does not receive any individual counseling. I believe that's kind of been the case throughout this case of he was evaluated for it and it wasn't deemed. He could fully participate to the full extent, but he does receive medication management services. He's up to date on dental. He's due for a medical appointment, a well check. His last one was in April, so he'll have a new one this year. He receives vision services as well. He had a TRT completed in October of this year, and he will have another one in March of this year. He does receive and has participated in ILP services. He did Georgia Crew during this past summer. He participates in extracurricular activities at his placement, and kind of looking more forward to his plan upon turning 18. The plan is for him to, I don't want to mess this up, one moment. When he turns 21, he will transition to DBHDD services. He's on that list. He's a preliminary approved now comp for that. He's on the planning list. And kind of, once he signs back into care, there will just be some staffings to monitor his progress toward transitioning to that service. But that's the plan once he ages out of care at 21. And the department as well, when that time comes, will petition for a state guardian to assist him with making major life decisions.
The judge wants to know that same thing. V.
And I believe those are the main highlights I have, Your Honor.
Does anyone have any questions for Ms. Gravitt based on her proffer?
Just a couple.
Go ahead.
Is there any, has the placement gave you any indications that he will be disrupting because of his behavior, or they're saying even with his behaviors, they still continue to have him for the long term?
I'm not aware of any potential disruption
Okay.
due to his behavior.
And you said that you think that he will sign back into care. Why do y'all think that he will sign back into care?
That's just my understanding based on the conversations with the department, that it would be in his best interest to do that, and I can confirm with my client, but I believe the department feels that way because he's expressed an interest as well.
Okay, that's all the questions I have, Judge.
And along those lines, has Hunter been involved in the discussions of the development of this plan, and specifically involving him checking back in?
I can double check that with my client, Your Honor. Your Honor, my client's report is that due to his diagnoses, he's limited and fully engaged in the discussion of his plan, but to the best of the department's ability to include him, they did.
And how would he then, logistically, what would be the mechanism by which he would check himself back into care? Is that something he individually would need to do, or he would do that through his counsel, or express that, or how would that be effectuated?
One moment, Your Honor, I don't
Sure.
want to misspeak.
And my other question, does he have contact with or communication with or visitation with anybody at this time?
Your Honor, I believe he visits with his advocates, the department, and he has his adoption recruiter, Ms. Brown.
All right, no,
Wendy's Wonderful Kids. No relatives, to my
Okay.
knowledge.
there are no people that would be in a position to dissuade him from checking back into care?
Not to the department's knowledge.
And I understand, correct me if I'm wrong, but from your proffer that he would, assuming that he checks himself back in, he would be, he could stay in care until 21, and during that period of time, the department would seek the adult guardianship to transition to adult services? When would that commence? When would the process of obtaining the adult guardian commence?
That's what I'm checking with. It'll be before he's 21, so that
I understand it takes some time to do, though, does it not? I mean, we start that process before he turns 21, right?
Yes, certainly.
And so, Ms. Gravitt, we would continue to have, well, what I guess would be permanency hearings, not AERs, but is that right?
Yes, Your Honor, upon him signing back into care, the department will submit the necessary written report to the court for the court to schedule an initial extended care services review.
Right?
And should the court find it would be in his best interest to receive those services, it would just be 18-plus court reviews moving forward. No, I'm still getting clarification on your one question.
Right, about checking back into care, how he does that. I'm also interested in the nature of you mentioned ILP services. Those are being provided to him at this time through his placement, or how and what are those?
Your Honor, I know typically how those work is those opportunities are sent to the placement, and then the placement just engages the youth if they want to engage in that. I know he attempted to take his driver's permit exam. I believe he did not pass that. But to the extent that he's able to participate in those services, he's certainly welcome to. And Your Honor, as to, the assistance of him signing back into care, I believe if that's something like his guardian or attorney could assist with talking with him about, the department will talk with him about that.
Can he sign back into care through his counsel?
Should be able to, Judge.
I would think, I know he needs to be the one, it's my understanding, to sign the document because he doesn't
Right.
have a state guardian at this point. But certainly if his counsel be engaged in those conversations and encouraging him to do that.
What if he doesn't? Then what happens? We don't have a guardian set up for him as an adult, correct?
Correct, Your Honor.
So what would that look like?
I do not have an answer for the court, Your Honor.
And
So this judge wants to know now, before he turns 18, what's going to happen to this kid when he's 25? 21. What's going to happen to this kid? This judge knows this case better than anybody sitting at that table right there. And I'm not guessing on that. You're going to find out soon. Well, no, you're going to find out later.
how he needs to wait until he turns 18 and then check back in, or is that something he can do in advance of approaching birthday?
Your Honor, it's my understanding that the department will meet with him on or very near his birthday to execute the necessary documentation for that.
But early enough to leave time to establish a guardianship in the event he expresses the opposite of what you expect?
Your Honor, I believe that process would not begin until, I mean, it would begin before he's 21, but not before he's 18.
But if he didn't check himself back into care for whatever reason, he'd be homeless and without a guardian?
Your Honor, I don't have a definitive answer to that, but he would be without a guardian at that point in time.
All right, are there any other questions for the department?
No, Judge.
One other question. I don't know if it's in the case plan or the report, but about psychological evaluation. Is that something that is referred and will be taking place anytime soon?
The department was working to get that updated for ABA therapy. A referral was sent out to Georgia Hope. So they're just trying to get with the AmeriGroup coordinator to get that going.
That was it, Judge.
All right. Ms. Devine, do you have any thing you'd like to present or any proffer you'd like to make?
I'd love to make a proffer, Judge,
All right.
and give Hunter the opportunity to speak with you if he
Okay.
wants to. Hunter is doing well in his placement. He is well loved there, and he loves it there. And so I fully anticipate he's going to sign himself in, and that will not be an issue.
Okay.
His goal in life is to buy a house across the street from his HSP and live there forever, right across the street from her. So
All right.
he
Does he
only
have
has a
something?
bad day when he doesn't get to sit in her office for a while. So
All right.
that's Miss Percy, Miss Gris Percy. She's been with him for years, and so they're very good friends. So he's doing well. He participates in activities there at the center where he gets to have cash to go shop with, and he only has an outburst maybe twice a month, according to Miss Percy, and that's usually when he doesn't get to see and sit in her office as much as he would like. Or there's one other individual he's fairly attached to there, so that happens. Doing well in school other than being sleepy in the morning, so I'm glad he's up and awake this morning. He looks great, and he's got his glasses too. I was afraid those were lost, but that's happening. He's in good health, and he's well adjusted there. He wouldn't want to move at this point.
All right.
So that's all I have. And Hunter, do you want to talk to the judge? You have to unmute yourself because we can't hear you. There you go.
There you go.
Hello? Go ahead. Hello?
Good morning, Hunter. How are you?
Good.
Good. I'm glad to see you today. Your lawyer was asking if you wanted to tell me anything or ask me anything.
I do like gift cards.
You like gift cards.
Yeah.
What do you like to buy with the gift cards?
Collect them.
Do you have all the gift cards you need?
Yeah, I do.
Good, good. What do you like to do there at your placement?
Having fun.
Yeah? I like to have fun too. You have friends there?
Yeah.
Yeah. And everybody's taking good care of you?
Yeah.
You ride your bicycle?
I don't have a bicycle.
You don't?
Mm-mm.
Okay.
Is there anything else that you'd like to tell me?
No.
Well, I really appreciate you coming. I haven't seen you in quite some time, and I'm very happy that you took the time to be with us today. It's good to see you.
Thank you.
Mr. Vine, did you have any questions you wanted to ask Hunter?
Just one.
Okay.
Who are the Sharks?
Jacksonville.
Oh no!
Okay.
It won't let me stop it.
Is that,
You have to remember that she just asked that. Unbelievable. It's unbelievable that she asked that question in this hearing. We're going to find out why. She just asked him who are the Sharks because he has a shirt on that says Sharks.
what kind of team is that? What kind of sport?
I don't know.
Okay. It's a cool shirt, though.
Thank you.
Right. That's all I have, Judge.
All right. And Ms. Devine, it sounds like, I mean, I'm just being alarmist, but at the same time, I just want to be sure that everything's going to go
Yeah.
like people hope and expect it's going to go. I mean,
Right.
do you have any doubts that he would check himself back into care?
I can't imagine it, that they wouldn't, I just can't imagine it. I don't just see any indication of that because of the bond that he has there. He's
Right.
very happy there.
And I would
So-
hope that that would be the case.
And it's-
If he weren't to check himself back in, though, that there would be some other things that need to happen, would it not?
Absolutely.
And what would trigger in the event that looks like it's going to happen? Is there, what do you think needs to happen, and how would we to get that done?
I know. I'd have to talk with the home there. I would think it would start with them and what happens physically with him, and could they extend it for a while until we get things straightened out as far as a guardian and that sort of thing goes. I can't imagine that they wouldn't, but
who
I
would
guess that's
fund
where
that?
I'd start and probably need to have a conversation with them about that.
And
just-
what is, when is he eligible to make that election? Does he have to wait to his birthday, or is that made in advance?
I don't know. That's up to, you mean the election to stay in
Right.
care? I thought it was 6 months before, so I'm kind of surprised, but, I don't know. I guess these facts would have to tell me that, but I would think that he could make a decision and sign that paperwork before his birthday if he wants to.
And I can provide some clarification to that. My client indicated they will meet with him in March in advance to review and discuss him signing back into care.
There's a TRT in March, right?
Yes.
Yeah.
There's
so
also a TRT in March.
I'll
Okay.
attend that, Judge.
You'll
and
be
we'll
there
have
for that?
discussion, yeah.
And in the event that there were any unexpected positions taken, you feel you could pivot
Put
in
something
the
in
amount of
motion,
time between
right.
March and June?
Yes, sir.
All right. Does anybody have any questions for Ms. Devine based on her proffer and Hunter's comments?
No questions from me, Judge.
All right.
No, Your Honor.
Mr. Amadou, do you have any presentation you'd like to make?
Just a brief report. Really, when it comes, I'm in agreement with the report that's been made by the department. I also wanted to just add a few more details from the last meeting that I had with Hunter. Hunter, he's a extremely really sweet, kind kid. One thing about him is he has a great memory. He has an awesome memory. When it comes to cards, I do believe that he does want more cards. He has a ton of cards, gift cards, and he loves them. And so if the court, anybody has extra gift cards, whenever we go down, we can give them to him, and it'll make his day. He goes online and checks the amount of money that's on the gift cards, and he does it all the time. He just loves having them. He also likes socks. He likes really like themed socks, like with, like SpongeBob and like different characters on his socks. Like he likes that, and he takes the gift cards and he keeps them in his socks. He also he likes keys too. So if you got old keys, he likes keys. He takes them and puts them on his necklace, and he really enjoys having that. He likes collecting things, but he can tell you, where I bank, because he knows. Like if you ask him right now, I'm sure he could tell you, because he knows the cards that I have in my wallet, because he loves cards. But he cannot have that card. I've told him that. But he's doing really well in the placement. Like everybody loves him there. Everybody loves him, and like they really take time to spend with him. And so this is his family. And so I would have to, and I'm going to be making the request that, if somehow, which I don't see how it could happen, but I would want for in March, when the department does speak to him and they, go over signing that form, if he does decide to sign himself out of care, we need to have like an emergency intervention, because I don't believe that's what he wants at all. But if somehow were that to happen, we need to, come in and, make some changes ASAP.
Right.
But again, Miss Percy, she spends a lot of times with them. Also, Mr. Trevor, he's the COO for the Morningstar organization. Hunter really, really loves him. And he loves Hunter as well. And so Hunter goes to his office, and Hunter listens to 80s music with him. And I guess Hunter
80s music in particular?
Yeah. I don't know much about it. Hunter does. I guess Boston is a group that Hunter likes. And they both they listen to that music together. Hunter loves Oreos. He loves Oreos. And he also likes those soups, those cup of soups. I forgot what they're called. So he is in a rhythm there. He's been there for a very long time. This is pretty much the home that he knows. That's why he wants to build a house right next door, because that's all he knows.
Right.
Let me see what else I got. He did. There was a talent show last year. I forgot about this. There was a talent show last year, and Hunter, he came out of his shell a little bit, and he danced at the talent show, and that was something that I learned about, that I was surprised to learn about. That's really cool. Placement is working on life skills with him, even though he's not in therapy, but they do work on life skills with him. He is becoming more friendly. As Mr. Trevor told me about a trip where they went to Walmart, and he introduced himself to one of the workers at Walmart. And so they're like, hey, that's great you're being friendly, but they're also teaching him how to protect himself from strangers as well. So he's getting some life skills like that. He also learns sex ed through the placement. They have those classes, and Hunter's participating in those classes. He got a $100 gift card from Walmart for participating in that class.
Wow.
They offer a lot. Hunter, for some reason, I don't know what it is about Jacksonville, but Hunter likes Jacksonville in general. He's told me that he wants to live in Jacksonville, but I'm wondering, I don't think he's ever been to Jacksonville. Or maybe they did a day trip down there, but he loves Jacksonville. And I like Jacksonville too, so I get it.
Right.
He for the most part he does well. There are some disruptions, he does in his history have a history of eloping, a history of being aggressive verbally and physically with others, peers and staff. A lot of the times, when he gets the most upset is when a staff member that he really wants to see, like say, for example, when he comes back from school, because even though the school is through Morningstar, it's not actually at the placement, so they take a bus there. He'll come back from school, and if like, you know, Mr. Trevor or someone else is in a meeting or they're not there to meet him when he gets off the bus and he can't have access to him, he you know, does get upset. But it's just because he's just so attached. But besides that, you know, he's really, you know, those behaviors are few and far between, and it's just because he's so attached. Like he wants to see these people every single day. They love him too. They spend a lot of time with him. So I don't want him to be anywhere else. And yeah, that's pretty much all I got to report, Judge.
All right, thank you, Mr. Amadou. Does anyone have any questions of Mr. Amadou based on his presentation?
No, Your Honor.
All right, thank you. Is there anything else anybody would like to present or that we need to cover at this time?
Your Honor, I do have the permanency report updated.
Could you show that to council?
Yes, I don't know if they have it pulled up. I left 4 blank. A termination has already been granted in this case.
Okay.
Ooh, thank you. A-D-G.
That's fine, Judge, with me.
Me too.
No objection.
Any objection to D1?
With gift cards.
No objection.
All right, it'll be admitted without objection.
May I approach, Your Honor?
You may. Thank you.
Look like Hunter just got a haircut.
And we're looking down the road, but ultimately, when it becomes appropriate to apply for the adult guardianship, the department would lead that charge?
Yes, Your Honor, that's the department's intention.
Right, okay.
Josh, you would be a hero. We cannot reach out to these people in any way, shape,
All
or
right,
form,
any
but it would be
argument or
cool.
request for relief?
For me, Judge, just the same request that I made. I don't want there to be any change in his placement, and you know, if it comes on anybody's radar, we need to address that immediately with a team meeting, and then also, you know, necessary review hearing as well. Besides that, status quo, Judge.
All right, thank you. Ms. Devine, anything further?
No, Judge.
All right. Any argument or requests?
Just that the court find that the proposed permanency plan of non-reunification in APLA would be accepted, and the court find that the placement remains appropriate for the child, that he remains dependent at this time, and that the department certainly understands, you know, the court's concern as to will he sign back into care. The department has no indication that he would not at this
Right.
time. And I know typically if a youth opts to sign out of care or not sign back in, situationally dependent, we don't always have those conversations. But in this situation, the department recognizes the uniqueness of it. And so the department's happy to loop in advocates. Should there be any deviation from what's expected, I think everyone expects for him
Right.
to sign back in. And just for reasonable efforts by the department. That's all, Your Honor. Thank you.
And Ms. Gravitt, we're in February now, and he's going to, I mean, typically we would schedule a review 6 months out, but by that time he will have reached his 18th birthday. Should I go ahead and schedule anticipating, well, if he does check himself back in, then we would have a extended care review.
Yes, Your Honor.
Should I schedule a hearing at this time or wait until that time, or do I need to schedule something preceding his birthday?
It's my understanding, based on the code, that the hearing is scheduled following the department's submission to the court of the written report, which is just, it's kind of like a permanency report, and it also includes the voluntary placement agreement. So it's my understanding that is what triggers the court to schedule the hearing based on the code, but I don't anticipate the department would have an objection if the court wanted to schedule something ahead of his birthday.
All right. I will find reasonable efforts by the department. I'm very happy that Hunter is in a good place that he enjoys, and it's existed for some time, and the fact that it's persisted gives me comfort. I am going to ask the department to meet with Hunter in March and include Ms. Devine, the child attorney, and the guardian ad litem in that discussion, and that in the event that he does anything other than check himself back into care, including nothing, if he does nothing, then I would ask that the court be notified immediately and that, so that we can schedule a review hearing to discuss where we go from here. It sounds like everybody's on the same page and has the same belief as to where we go from here, and I join in that. I think that's a great plan. But and there's not a lot the court can do at this point, but I do want to make sure that we eliminate worst-case scenarios. So in the event that there's any issue about whether or not he's checking himself in care, I think we need to come together for purposes of addressing, expeditiously addressing Plan B. I'm not adopting Plan B yet, but if we need to get an adult guardian in place quicker, I'm concerned about the length of time that might take and what would happen in the interim. It sounds like that's not likely, but I just want to make sure that that worst-case scenario doesn't come to play, because I would not want to think about what that would look like if he were not in a placement for any period of time. Anything else I need to address? I'm not going to go ahead and schedule one now. I'm going to wait till either an emergency request is made or the department files a notice such that we have the...
Okay, and there's more. There's more coming once Hunter leaves.
extended care hearing scheduled at that time. Ms. Gravitt, who would you suggest drafts this order?
Your Honor,
And if you're not all up in your feels already from this case, oh my gosh, you will be.
it's my understanding that the parameters of the orders we can draft is very narrow. And that this may not fall into the purview of the ones we're available to draft.
I can have Ms. Kim draft it, but I'm concerned that as the last order, it may be something y'all really need to put some stuff in. I'll leave that to you, but you tell me. I mean, what do you want us to do?
Based on what I've been instructed as to the ability to draft, if Ms. Kim is available to draft, or if the court is available.
All right, we'll take care of it.
Thank you, Judge.
If you have any parameters that you think that need to be included in that order specifically, you might forward that to Ms. Kim. Otherwise, we'll prepare that.
Thank you, Judge.
And I do find that the plan of non-reunification in APLA is an appropriate plan, and I will adopt that. I think the adoption is not the plan at this point, or a likely outcome at this time. All right, I thank y'all for your work, and I appreciate you being here. I have been receiving consent orders in this for some time, and which is fine. I always encourage that, but I really wanted this to be in person so I could lay eyes on the situation. It's been a while, and having Hunter appear and speak to me really makes my day, and I'm glad that we did this. So good to see you, Hunter. I'll see you again, but you keep up the good work and enjoy the people around you.
Bye.
Bye-bye. Today is 27. All right. I think that's everything. Is that right? All right, I'm going to bring this feed down at this time. All right, Hunter, you can get back to your fun times. I'm going to end this feed, okay? There we go. How long you been on this, Miss Devine? Did you have pre-termination?
No, I got it from Michelle Hall when she left, whenever that was. When was
Right.
that? So I was post-termination.
The thing that struck me, and why I ask, is that when we dealt with the termination early in the dependency case, there was a lot of testimony that was introduced about the abuse that he suffered in the care of his mother and grandmother. And one of the things that he went through is that he was locked in a closet for extended periods of time by them. And in the closet was the vacuum cleaner that he was very scared of. And they would threaten him with getting the vacuum cleaner out, which they called the shark. And he had this fear of the shark. And that was one. So that's why when I saw the shirt and we started talking about that, it kind of, maybe he doesn't have that memory at this point. But that was an unusual fact in this matter that was very strange.
I had not heard that. They're a professional indoor football team.
Right. All right.
I didn't know it existed.
So it just, it's that to me is the system working, and not just working. This judge has a firm hold on what's going on with this little boy. I mean, he's 17 now, but they don't. That it's the guardian ad litem way on the left. Then it's his lawyer who asked about the shark shirt, and then the state. But the judge not only wants to know what's going on now. He signed the permanency. The parents have no chance of getting the child back now. They're not even working towards it. It's over. And they don't think he's going to get adopted because he's going to be 18 in less than 6 months. So now what are we going to do with this kid? Because, in less than 6 months, they could just kick him out and say, okay, you're an adult now, go live your life. But no, they have all these plans in place for at least until he's 21. And it sounds like right before he turns 21, they're going to make sure that he signs up with a adult guardian. So, but what a question. When she asked about that shirt, I didn't know. I didn't know until the end, just like you. And I was like, whoa, that's crazy. All right. Let's go to, this judge isn't really fast by any means, but we're going to go, this was Hall, Georgia, and we're going to go to Indiana.
And
Marshall.
are you currently employed there? You mentioned kind of if you lose your job or keep your job, or are you currently employed there?
Yeah, they're holding my job, but they're only going to hold it for so long. I mean, if I don't get out, then I don't have it.
And have you completed work for them in the last months that you've not been paid for? Meaning, are you expecting to receive a paycheck in the future for work you did prior to your incarceration?
No, I'm already paid up for all that. They're just holding my job for me for right now.
And also fair to say you're not paid anything while you're incarcerated, correct?
Yes, sir.
And do you have any other income in any source?
No.
Do you have any bank accounts or checking accounts with a positive balance in them?
I have a checking account. And yes, it has a positive balance in it.
How much is that?
Probably like $600, if that.
Okay. Any other accounts, financial or otherwise?
No, sir.
Do Do you have any collections or items of decent value that you could liquidate?
Yeah, probably.
Does anyone have access to those while you're incarcerated that they could assist you in liquidating them?
No.
What would you approximate the value at?
Probably about $1,000, if that.
And the address you provided, do you rent or own that?
I rent it.
What's the approximate rent you pay per month?
$550 plus electric. So I probably all together in a month, I probably pay $600, maybe $700 altogether.
And are you anticipating posting the bond in this case?
Not at $1,500. No, sir. I can't. I don't have the cash for that. Like, I don't.
Is anyone else going to post that bond for you?
No.
As of now, I'll find that you qualify for the appointment of a public defender. The fact that you're employed, if you're released, causes me some hesitation, but you're not receiving that income right now. Additionally, it sounds as though you've got $1,500 to $1,600 in either cash or assets that you have access to. And so if you were to post a bond and then regain employment, I might reevaluate your qualification as a PD. I also note that you appear to have a public defender appointed to represent you in another case. And so just want to point out that it appears that there's been a prior determination that you qualify. So I'll appoint the Marshall County Public Defender's Office, and the jail staff will provide you their contact information. More than likely, you'll have the same attorney representing you as in the other case, but I defer to them on exactly who's going to be appointed in your case.
All right.
What that means then is for the pretrial conference, you don't need to plan on being here because the attorney will be here for you. The status hearing of May 7, 2026, that's the next day you need to be here. That's at 9 a.m. Do you understand you must be here at that status hearing on May 7th?
So before he answers, I have a question. I wonder. So the judge is assigning him a public defender, right? And if he gets out, if he posts bond and he gets out and he starts working again, the judge may take that away. Now, let's say he likes this public defender. Are you allowed to hire public defenders? Are you allowed to, pay them? Are they allowed to take cases that aren't? Because their caseloads are so full. So are you allowed? Is he allowed to give him a retainer and keep him on? I don't know.
Yes.
In regard to the rights or the range of penalties or the information we've covered this morning, do you have any questions over that thus far?
I do have a question. So you said that my bond and stuff. So they read me a warrant last night for a probation violation, and as far as I understood, I wasn't on probation according to my lawyer, and I haven't been to probation in like 5 months. I mean, they should have read me that when I got arrested. I shouldn't even have a bond, but now they want to hold me with no bond. I don't understand how they can do that.
Well, I appreciate the fact that you don't understand that. However, we're here in 50D03-2602-F618. Clearly, you're not on probation in this case, and I don't know that case is pending here in Superior 3, so it'd be inappropriate for me to just offer you legal advice and the appropriateness of what probation is doing in another case. So I can't really answer that question because it's not appropriate for me to give you that legal advice. I can tell you that your bond in this case is $1,500. I was going to address your bond, which has some relationship to the fact that they're alleging you're on probation in the pretrial release recommendation. That recommendation also notes that you have another sentence in 71D022506CM1293, and that's in St. Joe County. It also notes you have 2 past failures to appear, one from 2023, one from 2017. And then it notes there are 3 pending cases, all in Superior Court number 2. So that's 50D02, 2505CM560, 2412CM1417, and 2308CM826. Now that CM826 cause, the pretrial release notes that they're alleging you're on probation in that case. I don't know if that's the case that you just referenced in regard to the warrant for that violation, but that's at least what the pretrial release recommendation is alleging.
You mean for St. Joe County, correct?
No, that it is indicating 50D022308CM826 is the case. There's the violation. So
all right.
I don't know anything else about the St. Joe County cause other than the pretrial release, and pretrial release information lists that cause number, which is a different one, 71D022506CM1293, but it doesn't really note much about that other than there's a consecutive probation sentence in that case. Now, in regard to your bond, obviously, if there's some hold on you for another case, you have to handle it in that case. That's largely what I'm advising you when I say I can't give you information or provide you legal advice. You'll have to address that in that other court. And I'm sure that if there's a violation that's been filed and a warrant's been read, they will have you into court relatively quickly on that. What I'm addressing now is your bond in this case alone. And so that's what I'm looking at in setting a bond. I'm going to hear from the state in regard to their recommendation and then come back to you for any recommendation or request you have. So, Mr. Langowski, what is the state's recommendation?
Thank you, Your Honor. Given that he was alleged to be on probation, alleged to have been sentenced to a consecutive probation sentence in St. Joseph County, we believe bond is appropriate at the $1,500.
And Mr. Overfield, as it relates to this case, and I recognize you're wanting to have that hold lifted in another cause number, but recognize I don't have the authority to do that because that's not my case to be addressing. I'm just looking at this bond here. Do you have any information or request in regard to this bond?
I mean, yeah, I would like it lowered so I can at least try to get out of here, keep my job and keep my apartment before I just lose everything. I mean, that's crazy. Like,
well, the factors that weigh in your favor for lower bond are that you have a Bremen, Indiana address. It appears that you have some establishment in the community with a job, et cetera. The nature of the charge is not altogether alarming in the sense that it's a status offense. No harm was threatened, and I don't have any information to believe that harm was actually committed in the nature of the offense. It's a level 6 felony, so the $1,500 bond is a standard on a level 6 felony. So it's not as if your bond's being elevated any more than what any other person for this type of charge would have. Things that vote against lowering the bond are things like the fact that it's alleged you're on probation in 2 counties, one here and then one in St. Joe County, and also the fact that there's at least 2 other pending cases in addition to the alleged probation case in Superior Court number 2. Now, I don't know the nature of those cases, so I take it with a grain of salt and or limited value, but they are pending cases. The only thing that really is positive in that regard is that they're out of Marshall County, and so it's not as if you have to be going to multiple jurisdictions to address the hearing dates that are being scheduled in those cases. I understand what you're saying, Mr. Overfield, but frankly, I think that the $1,500 bond is appropriate given all of these circumstances. Again, as I indicated, that's a standard bond on a level 6 felony. So I could raise it for some of these things. I could lower it for some of these things, but the factors on balance justify that $1,500 bond that was set. So I'm going to affirm that bond as now, and as I indicated, any other holds would be honored. So if you post this bond, you'll still have to address those other holds. Those may or may not be concurrent with this case, and I leave that to the jurisdiction of the other courts to do that. So if they set a bond It'll have to be clarified with the jail whether that's in addition to this bond or whether this bond would satisfy that bond. But on this case, it's $1,500.
Okay.
As it relates to the hearing date, the status hearing is May 7, 2026. Your public defender will be in contact with you, and the jail staff will provide you the public defender's office, so please get a hold of them. Do you have any questions over the information we've covered with you?
I'm supposed to get a hold of somebody inside of a county jail? Like, I don't understand that. How am I supposed to contact somebody when I can't even, like, this is crazy, dude.
Mr. Overfield, let me ask you a simple question.
Yeah.
Do you know how to dial a phone?
Yeah, but what number am I supposed to call? Like, you guys just tell me I'm supposed to get a hold of people. I know there's people in the back that's been sitting there for 4 months because their attorney don't even come and see them. I'm not trying to be sitting here for 5 months, dude, without even knowing, like, what the hell is going on. You know what I'm saying?
Sergeant Diltz, can you hold up what you just had in your hand? And Mr. Overfield, can you turn around and see Sergeant Diltz there?
I see him in the camera, but I mean, he I'm not going to sit here and argue with you, dude. Like, it's whatever.
The phone number listed on the card is how you call that. It's a free phone number for you and anyone in the jail. So you call that office without any sort of payment. So you can call them. They'll give you information about your public defender. As it relates to when they will see you, I don't arrange their schedules. So you'll need to talk to the public defender office and they can give you further information from there. Thank you, sir. You can have a seat in the back.
Yep.
You have an initial hearing on a pending motion to revoke probation. There are some key distinctions that I'll draw to your attention between those two types of hearings, but generally the information that I'm going to cover at this initial hearing is the allegations by the probation department, the rights you have as someone that's been alleged to have violated your probation, as well as the range of penalties, and then we'll talk about some procedural matters of how we move forward here today. You were placed on probation by way of a conviction for possession of methamphetamine. That was as a level 6 felony, and that conviction carried with it at the time a sentence of 2.5 years in the Department of Corrections. 6 months were suspended, and then you had 2 years served through community corrections. The 6 months that was suspended is now the effective range of penalty. And so if you're convicted of this offense, or I should say convicted of having a probation violation, then that 6 months could be imposed in the jail or Department of Corrections, or any lesser amount of time could be imposed as well. You could have community corrections imposed if you qualify, and you also could have modifications of your probation terms at the very low end of the sanction. And essentially that is the range of penalty. And do you understand that that's the effective range of penalty that the court could sentence you to if you're found to have violated your probation?
I do.
Now, you have certain rights that attach to you as someone that's been alleged to have violated your probation. The most important right you have is the right to a fact-finding hearing. That fact-finding hearing would be before the court, not before a jury. What that means is that the court, myself, would hear the information and then make a decision about whether you have violated your terms of probation. At the fact-finding hearing, the state's required to prove that you committed these violations by a preponderance of the evidence, meaning more probably true than not. That is different than an underlying criminal offense, because the underlying criminal offense burden of proof is beyond a reasonable doubt, and by a preponderance of the evidence is a lesser standard, as I indicated, meaning more probably true than not. At the fact-finding hearing, you would also have the right to bring witnesses in to testify, and you'd have the right to have an attorney represent you throughout these proceedings, including at that hearing. And at the conclusion of any contested probation hearing, you'd have the right to an appeal. Do you understand that you have that set of rights, ma'am?
I do.
Any questions over those rights?
I mean, I'm willing to plead guilty today. I'm not wanting a fact-finding hearing.
And we'll get to that in just a moment. I'll give you some further information before you want to actually formally admit that. I also need to hear information from you or the state about one of these alleged violations, because it impugns your Fifth Amendment right to remain silent. So we'll come back to that in just a moment, but I appreciate that information. Do you have any specific questions, though, about the rights that I've outlined for you?
No.
Now, the violations are as follows. This is from the motion to revoke probation, which you should have. There's a violation of term number 1, where they're alleging you engaged in criminal conduct and you were charged with driving while suspended as a Class A misdemeanor. And also count 2, improper or no taillights is a Class C infraction. Count 3, no headlights is a Class C infraction under cause number 50D02-2512-CM1359 in the Marshall Superior Court number 2. It's also alleged a violation of term number 7 in that you submitted to an oral swab on November 25th, 2025, and that oral swab tested positive for amphetamine and methamphetamine. At this juncture, I'm not asking that you agree or disagree that you committed those, but do you understand what is being alleged, Ms. Bolenbacher?
I understand.
Now, as it relates to the recommendation from probation and the state, if there's a violation or in fact there's an admission, what's going to be your recommendation, Ms. Turnage?
The recommendation from probation, if she admits to the violation, would be 19.
And then terminate probation?
Correct.
I'm sorry, I didn't hear 90 do what?
90 days county jail, probation terminated.
So this Turnage is going to be recommending that you serve 90 days in the Marshall County Jail. Obviously, that's subject to good time credit and credit for time served. And so you actually do 45 days in jail. But that's what their recommendation is. Is the state willing to abide by that recommendation?
Yes, Your Honor.
And this is just a general question either for you, Mr. Langowski, or Ms. Bolenbacher. I see that there's a new criminal offense allegation. Is that criminal case currently pending?
I believe so, Your Honor. I'm not entirely sure. Pulling it up right now, Your Honor. There was the initial hearing on it was on the 16th. It appears that there was possibly a warrant issued. And then there was a hearing on the 5th that released her on.
People who live in the United States, do you guys all have Fosnot Day coming up? Or is that just a Pennsylvania Dutch thing?
Her own recognizance. It's still pending, and there is a status conference for June 17th on that.
Can I say something?
Well, I don't want to get far into the weeds on that case. I just was asking Ms. Bolenbach. The reason for that is the state is alleging that you committed that new criminal offense and that'd be a violation of your probation. You have the right to remain silent on that new criminal offense. And so if you were to admit to the violation, the state could ask you to then admit to that you committed that driving while suspended, which would be violating your Fifth Amendment right to remain silent.
She cannot remain silent. Don't worry, guys. We're going to hear her tell her story in a second. And she cannot remain silent. Yeah, it's like a donut. It's like a donut. So Lent is about to start for Catholics. So before Lent starts, you're supposed to like use up all this stuff in your pantry so that you don't eat it during Lent. So we have Fosnot Day. And Fosnot Day, there's powdered, there's sugar, there's plain. It's just like a donut, only it's more square. It's not like a circle with a hole in it. And you eat Fosnuts all day long. But they're just like donuts. They're not great. There's not like filling or anything in it. It's just like a powdered or a sugar donut, only it's square. But that's coming Tuesday. Tuesday is Fosnut Day. So everywhere in Lancaster you go, you'll be able to get Fosnuts. I'm getting Fosnuts.
On the new charge. I also can consider appointing you a public defender in this case in the event that you have a public defender representing you in the other case.
I do not. I'm going pro se. There was an agreement made that I could be released and get my SR-22 and provide the verifications, and then they are going to drop it. So I'm going pro se, and I would like to go pro se on this case.
The main question I have for the state at this juncture is that if she's wanting to admit to the failed drug screen, is the state going to insist on her admitting to the new criminal offense to abide by the 90 days? Or will the state allow her to simply admit to the failed drug screen and then ask to impose the 90 days in the Marshall County Jail?
We would ask that she admit to the failed drug screen, not the pending criminal case since it is pending, and then abide by the recommendation.
Okay. So, Ms. Bolenbacher, that at least clarifies the issue of the Fifth Amendment. You would not be required to admit that you committed the criminal offense under 50D02-2512-CM1359. The state would just want you to admit to that failed drug screen and then presumably still ask for that 90 days in the Marshall County Jail. Now, none of that means that is a requirement that I impose that 90 days, but that's just simply information for you to know that they're going to be asking that you serve that time in the jail, and that is 1/2 of the suspended sentence. You had previously indicated you wanted to admit to the violation today and then just move forward with sentencing. Now, with that information that the probation department and the state is offering you, that they're going to be asking for some.
I do understand. I have some things I would like to say before I admit, if that's possible.
Is it in regards to the violations, or is it about what you want the sentence to be?
It's about the violations. Well, I mean,
About the failed drugs,
yes.
either or there, not both. So is it about the failed drug screen?
It's about the failed drug screen and the fact that I was told to go and start my Elkhart County probation, and I was supposed to be, my cases were consecutive, and now I'm getting violated on both of them after Mr. Fallon had told me on December 4th, my last day of probation. My last meeting with him was the 25th. So I have a series of events that had happened, and now I'm getting violated on both counties. And I've turned myself in on all the warrants. But I just have some dates that I want to read of things that had happened.
Well,
because this.
Ms. Bolenbacher, you said you wanted to read that before you admitted, and I just want to clarify for you, it would be inappropriate for me to hear that information if you ultimately are not going to be admitting to the violation. Now, I'm not trying to make it sound like you must admit to the violation here today. To the contrary, you can ask for a public defender. I can schedule hearing dates, and then I'll address your bond. But I can't allow you to simply go on about what you believe the state is alleging or clarifying some information, because some of that may be actually incriminating for you. And unless we're going forward with an admission hearing and a sentencing, it's not necessarily appropriate for me to hear all of that information at this time. So I really need to clarify, are you wanting to admit to the violation and then be sentenced today, or are you wanting to have some hearing dates scheduled moving forward where you would then either have an attorney representing you or come up with some arrangement with the state representing yourself?
Is a bond possible? Because I had to take a leave of absence at work, and Mr. Fallon had told me to sign my lease for my apartment on December, and now he told me that it would be fine. I seen him, and I signed a lease, and I took a leave of absence to handle this, and now I'm going to lose my apartment, and I would like a bond so that I can continue to, I guess, fight this. And I don't want to fight it, but I'm not willing to agree to 90 days today.
All right. So what I'm hearing is, first, you don't want to admit. Second, you'd like to represent yourself, not have an attorney represent you. And third, you'd like to ask for a bond and then have some hearing dates moving forward. Is that all correct?
Correct.
Just to be clear, you know you have the right to be represented by an attorney, but you're deciding not to be represented by an attorney. Is that correct?
Correct.
You do not want me to consider appointing you a public defender. Is that also correct?
Correct.
Now, as it relates to your bond, well, let me do this. Let me get the hearing dates for you, and then I'll set your bond. The hearing dates that I'm going to schedule are a pretrial conference.
Actually, I'll just admit it today. I'll plead guilty today. Give me the 45 days.
Ms. Bolenbacher, no one's forcing you to go one way or
I know, but I don't have time to, my son's graduating at the end of the year, and I'm trying to clear this all up so that I can make his graduation. So I just want to get this done. I'm not trying to sit around and come to a bunch of court dates and not be able to go to the graduation. I'm sorry. So I'm ready to give me the sentence.
Ms. Bolenbacher, main question here is, Do you understand the rights that I outlined earlier?
Yes.
And if you go forward with an admission today, do you understand you'll be waiving those rights?
Yes.
Do you understand that you're not going to be speaking to an attorney?
Yes.
And we're going to then move to a sentencing hearing after you admit. Understand all
Correct.
of that?
Yes.
Do you think that's in your best interest?
Yes.
And why is that?
Because I do not have time to go to a bunch of court dates and possibly miss the graduation.
Any further questions, Mr. Langowski, of her?
No, Your Honor.
And I just want to ask a final time, Ms. Bollenbacher. You've made a series of statements about what you'd like to do today. You've settled upon, it sounds like, admitting to the violation and moving forward. So the main part I want to get to is that you understand you have a series of options before you currently.
Yeah.
And that you're choosing to go down this avenue knowingly, voluntarily, correct?
Yes.
Forcing you to admit to the violation.
I hate to say this, but that's probably me. If I was ever in this situation, I wouldn't want a whole bunch of court dates. I was just like, can you just put me in jail? Give me my time. I don't want probation. Just put me in jail. I'll do my time, and then I'll get out. Then I don't have to keep coming to court dates.
Correct.
Correct.
And are you currently under the influence of drugs or alcohol?
No.
It's comical given that you're incarcerated, but I still have to ask that.
Yeah.
So you're not incarcerated, or you're not under the influence of drugs or alcohol. Is that correct?
Correct.
And then to the allegation of a failed drug screen on November 25th, do you formally admit that or deny that allegation?
I admit it.
And that was for amphetamine and methamphetamine. Is that correct?
Yes.
Was that after you voluntarily used one of those substances?
Yes.
Which one was it? Or both? But which one?
I used methamphetamine.
Any further questions on the factual basis, Mr. Langowski?
No, Your Honor.
Ms. Bollenbacher, you had indicated you wanted to read me a statement or provide me information. Can you do that now in regard to sentencing?
Yes. I was pulled over on November 23rd. I was with my daughter and I had no headlights on. I met with Mr. Fallon on November 25th. I informed him of the traffic stop. He informed me that if I possibly got my SR22 and got my license not valid, that maybe my charges would be dropped, and that was going to be my last meeting with him as long as my fees were paid by November 4th. And that once my fees were paid, I could start my Elkhart County probation. I was drug tested, but I did not inform him that once I got pulled over, I used. I should have informed him that I was going to be negative. I admit that that was wrong of me, or that it was going to be positive. That was wrong of me. I should have been truthful. On December 2nd, I finished paying off my fees. I called and informed and left a message for Mr. Fallon trying to clarify, is it okay that I start my Elkhart County probation? Because I did not want to be violated on both terms. He did not call me back. On December 4th was my last day of probation. So I then once again called Mr. Fallon and left a message asking to be clarified, was it still okay to start my Elkhart County, because I did not want to be violated on both. On December 8th, I still had not heard back from Mr. Fallon, so I went ahead and called Mrs. Andrews of the Elkhart County probation, and she said that I should have signed my terms on the 5th, but we could go ahead and sign them on the 11th. On December 10th, Mrs. Andrews called me to inform me that Marshall County had imposed a new charge, and that she wanted to know why Mr. Fallon told me to start my Elkhart County probation if I was not going to be finished. I informed her I was not sure. I tried to call him and ask, some clarification on what I was supposed to do on these two. On December 11th, I met with Mrs. Andrews. I signed the terms. Actually, on December 10th, she informed me that she was going to also be violating me because of the new driving charge. I met with her, went to my meeting, told her I was going to fail the drug screen, told her that I understood why she was violating me, she told me that even though she was violating me, I still had to come to my meetings, and I understood that. On December 15th, Mr. Fallon calls me and tells me that there was new charges being filed. He would like to meet with me. I see that this is 3 days after he put the warrant out for me, so I went and met with him. We discussed that I needed to get into some drug counseling, and that he thought that there would just be a hearing scheduled. Okay, that was on December 18th. He lets me leave his office, even though he signed a warrant for me 6 days prior. I still was unaware, though, that there was a warrant filed at that time. Okay, so I leave, and then my family informed me that I had a warrant. I called and emailed Mr. Fallon asking how come he let me leave the day before, and told me to sign that I would be fine to go ahead and sign my lease for my
House come, Judge. House come.
apartment, and how if we could come to an agreement on getting the warrant removed. I did not receive any contact back from Mr. Fallon. And I didn't turn myself in instantly because it was Christmas, and I needed to get my rent paid. I had to take a leave of absence at work, and I was trying to contact some attorneys about what to do, since now I had 2 cases consecutive. And also when I met Mr. Fallon on the 22nd, he asked me, how come you signed your terms of probation in Elkhart County? I hadn't discharged you yet, which I was not aware that that was a process. I didn't know I had to be discharged from him before I started my Elkhart County. And then, so I had Christmas with my kids. I paid my rent for up until March now, and then I took a leave of absence at work, and I turned myself in on January 20th to the Napanee Police Department.
Thank you, Ms. Bullenbacher.
That's a new goal I have now, Monica. I'm the relative. When I come over, all we do is eat. That's it. That's what I'm going to be known for in my family.
Small information that I'd like to clarify for you is that the probation department filed their motion to revoke probation on December 12, 2026. You'd indicated that Mr. Fallon was the person that was issuing the warrants. The court signed, meaning I signed the order for the warrant on December 17, 2025. That warrant may have gone out that day. It could have gone out the next day to the sheriff's department, but it might not have been active until near or after the time that you were speaking to Mr. Fallon. So I just want to clarify a little bit for you that it is possible Mr. Fallon did not have specific knowledge about when the warrant was issued, because he in fact does not issue warrants himself. He only requests the court to issue warrants, and oftentimes that's not automatic, where they request and immediately the court issues the warrant. So I just want to clarify for you that it may not have been Mr. Fallon was deceptive to you. He may not have known that there was a warrant issued at that time.
I understand.
Any further information or argument from the state?
No, Your Honor, we would just ask that you accept the recommendation that was previously outlined.
Ms. Bullenbacher, any further argument you'd like to make in regard to the sanction, knowing that the court could impose anywhere from 0 up to 6 months in the Marshall County Jail?
No.
First off, I don't think community corrections is appropriate. Just wanted to throw that out there in the sense that no one's asking for that, but technically she had community corrections before.
She didn't even ask for less time. She didn't even say, 90 days is too harsh. I already did this program and this program. I think 30 days would be better.
it may jump to the thoughts of everyone to say, why wasn't community corrections an option here? There was a revocation on the community corrections, but also the fact that there's a pending case causes complications for community correction supervision. Secondly, when looking at the recommendation being 90 days, it's kind of squarely within the range of the possible sentence here. It's directly in the middle. 180 days would be about 6 months, so 90 days is half of that. There's an allegation, but yet she hasn't admitted. She's made some statements about the charge, but yet has not admitted to the violation for the new criminal offense. So I have the failed drug screen. Little concerning to me was that she kind of knew there was a warrant, and for some time she evaded the either law enforcement efforts or simply didn't turn herself in. I just simply note that. I understand, and obviously it's human nature around Christmas time, the holidays, to not want to be around inmates at the jail.
I would not turn myself in on Christmas. I just wouldn't. I would take the extra time
And prefer to be around your family. However, in balancing all of that, it's a little concerning for me that you had the knowledge of the warrant and decided not to turn yourself in for some reason. Having said all of that, I think the 90 days is appropriate. What I will do then is impose that 90 days in the Marshall County Jail. You will be receiving good time credit and credit for time served. And so that is 45 days that you're going to have to serve on this. I would note for you that all the days that you're serving thus far will go towards that sentence. I show that you were incarcerated on February 4th, 2026. Does that match with your understanding of when you turned yourself in?
No, I bonded out of Elkhart County on January 30th.
And then from there, where did you go?
Here, I waited for Marshall County on January till January or February 4th.
Were there any other holds for you?
No.
I'll clarify with the jail of when they received notice that you were eligible for release. I want to note for you that I hear that you bonded out of another jurisdiction. There could have been a hold on you that needed to be clarified. And so if Marshall County was made aware on the 30th that you were available for pickup, you'll get credit for that time. If they were not made aware until a later date, you might not get credit until they were notified that they were able to come and pick you up in the event that there was some other hold placed on you at that time. At a minimum, it's going to be February 4th. So you can rest assured, I know that you'll get credit from February 4th. I just need to clarify with the jail between January 30th and essentially February 3rd, how many of those days they were notified that you were eligible for pickup. All of those will go towards the sentence, and then you have to finish serving the remainder of the 45 days. Any questions over the court's findings?
No.
Note for you is that if there's any unpaid fines, costs, or fees, those will be reduced to a civil judgment. And so just be aware that there will be a civil judgment for any unpaid fines, costs, or probation fees.
I do have a question on that.
Yes, ma'am.
The fees that are left are from community corrections, and those fees were paid up until I was put in Marshall County Jail for the last 4 months. So I was under the understanding once I went to jail, I did not have those fees anymore. So I would like I don't know, maybe I tried to call community corrections a couple of times to get a clarification, because I was under the understanding that I was only like $200 behind when I went to jail, and that the rest was like if I would have complete community corrections.
So I'm not necessarily addressing any community corrections fees that we're owing.
Okay.
I don't know right offhand whether there are community corrections fees. What I'm referencing are the fine, the court costs, and the probation fees. I'm not aware of whether there are or are not an unpaid balance. I'm just simply saying if there is, it's going to be reduced to a civil judgment, because we're not going to have any supervision over you to have you pay that.
Okay.
A final note for you is that this sentence is by statute required to be consecutive to any sentence that's imposed in 50D02 2512 CM 1359. I know you do not anticipate receiving a sentence in that case, but technically my sentence will be imposed consecutive to any sentence that may be imposed. It's also consecutive to any sentence in the 20D03-2311F61417, which is simply confirmation of the previously entered consecutive sentence. This jail sentence is consecutive of that as well. Once you're released, you'll have no further obligations to probation here. Obviously, you have some obligations to Elkhart County, which you need to defer to them, though. I appreciate your time this morning, ma'am. Thank you, Ms. Turnage. You can have a seat in the back.
All right, it's just so weird that this whole conversation happened in chat today. All right, first off, if you're here for court videos, they're over. Thank you so much for coming out today. I appreciate it. I really do. So, this is not about court. This is just talking. I can't believe you guys talked like this in chat today. It's really funny because I have something I wanted to ask you. I have this little, okay, I don't know if you guys, I bought a food truck in 2024 and that didn't work. I got rid of the food truck, but a couple months ago, I started working towards a coffee canopy. So I would, drive to a location every day, set up my little coffee canopy, and sell coffee, sandwiches, blah, blah, blah. But I was going to live stream the whole thing. I was going to have a GoPro or something on me and not the customers, or maybe a camera so it doesn't hit the customers. And we were going to live stream all day, okay? But then everything around me started burning. Literally, it's still burning. It's still bright, hot, on fire. But I'm trying to pivot back to getting the supplies that I need for this coffee canopy, right? But I was stuck on this one thing, and it shouldn't have stopped me from moving forward, but when I'm thinking about everything, my brain kept getting stuck on this one thing. I don't know if you guys have Taylor Chip. If you don't, you will probably hear about it in the future because they're growing. Okay, Taylor Chip is a little cookie company, and they make these cookies. They're outstanding. Each one is a delicious work of art. And they're oversized. They're big cookies, and you can get all the different flavors of these cookies. So they're like exploding. Like they're opening bigger and bigger and bigger places around here, and it's delicious. And then we have like Lancaster Cupcake Factory, and they're doing so well. They make cupcakes, but they make them extra. They're extra. So people just flock there to get cupcakes, right? Right? And then, Starbucks. Before Starbucks, people would get coffee with cream, and every once in a while, they would put, French vanilla creamer in their coffee. That was exotic. But, people wanted coffee, and now they have extra. This coffee that's extra. All right. I wanted to do my coffee canopy, but I wanted something. I wanted something like that people would love. It would be extra. I wanted it over the top extra. Yesterday I found out what I'm going to do. Are you ready? Are you ready for this? Cake rolls, but extra. Is it playing? Maybe I have to flip it. See, aren't they so cute? Look at that. So easy to make. See, I could do everything. Everything. Look at that. I must have been on a strawberry kind of mind when I was getting some pictures for this, but that is what I'm going to do. That is going to be my yeah, because, okay, yes, cake rolls, but more just rolls, because not everybody likes sweet. So, ham, egg, and cheese roll. And whatever it is, it just has to be cute and extra, because people keep coming back for that. But yep, I was thinking about sushi. Should probably be on my menu. Sushi is super easy. These cake rolls are super easy. And so yeah, so now I can move forward. Now I know. Now I just have to find the right packaging to display the cake rolls. And then learn how to bake a cake. No, just kidding. I know how to make cake. So, yep. So the next piece of equipment I'm going to buy is the van. Yes, I can decorate like that. And my daughter, she's a baker, so she's worked in a couple bakeries, so she's actually learned how to do it from a professional. But I think as a mom, I'm a professional. I know people go to culinary school and baking school and blah blah blah, but I've been baking for many years. So no, that's easy. I can't wait though. So yes, the next thing I'm going to do is get a van. You want to know why my next piece of equipment is a van? Because my son totaled my car. He's fine. Remember, he's fine. But so we have to replace that. So instead of replacing it with a car, we're going to replace it with a van. I can't wait. I have a wish list set up where me and my daughter go through and figure out exactly what piece of equipment we need next and how we're going to get it. And which cat is going to be my mascot? It has to be Lafayette. It has to be Lafayette. It has to be. I mean, I won't bake the cake here. I wouldn't make any of the food in my home. No, I would make it in a commissary kitchen. I can't send you free samples, Terry, but if you come, I would give you anything for free. All of it for free. Hard to get does not mean impossible, T. If it's easy, everybody would do it. Uber, Mel. Thanks, V. No, don't. He'll crash it. No, I mean, I can't. You mean like DoorDash? Yes, I already have my DoorDash set up. My DoorDash set up so the second I open for business, I can start selling them on DoorDash online. $40 minutes to go get coffee? That's crazy. But I'm really excited about the live streaming part. Because I don't know. Hopefully, I get enough customers that I can interact with, so the live stream's not like boring as hell. But that's the part I'm more excited about. But I have to put the cameras in a spot, in a position where I can get off camera enough so no one sees how many cake rolls I eat in one day. I really just want to open this food truck or this coffee canopy or whatever to have a food type business, just because, because I dealt with food insecurity so much in the past that now I want it around me all the time. I don't care. I want to work in a place where there's food around me all the time so I feel safe and happy. You know what I mean? So nothing is going to stop me from opening a food place so I can eat whenever I want and there's food. But I can't wait. That looks delicious. I would eat that right now. All right, guys. That's it. Well, it'll be live streamed. Starting a food channel sounds so exhausting. I would have to think about something to cook every day. And I know I already do that. I understand. But I already have to get court videos together every day. Every day I have to. I don't have a day off. I have to. I can't start a food channel and then I have to cook every day. Like my dinner yesterday was so good. It was pork tenderloin. And oof, it was good. And that would have been fine to show, but I don't know how to do that to you other than tell you what I'm doing next. That's what we're doing. I'm telling you what I'm doing next. You guys have a great day. Thanks for coming out. I appreciate you guys. See you tomorrow. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in